Good morning, good afternoon, everyone. My name's Roy Malone. I'm the Chief Executive of the Definitive Group, and today we're going to go over a very hot topic. We've got two great people with us today that will be joining me. Matt Payne will be delivering his part, and then we've got the lovely Kate that will go over more the legal perspective and a lot of the case studies that, with the little hidden gems of how some of the companies are getting themselves in a bit of hot water. So, and then finally, I will cover some of the redundancy side of things from a payroll perspective and just some of the points to look out for. So with today, the sessions will be passed through all the notes. You don't really need to take any notes. A recording will be available to everyone as well. And questions please just ask your questions throughout the presentation. And at the end of all the speakers, we'll go through the questions and ask all the nominated speakers to help out with those. So please don't be shy, just shoot through any questions you may have because it's a very hot topic in the market now, especially the lead up or the wind down of JobKeeper for a lot of businesses. So I'm going to hand it over to Matt. So Matt is the Managing Director of HR Expert. And he's going to take you through his part or his elements of the world and the way they see it. So it's over to you, Matt. Have fun.
Thank you very much, Roy, and hi everybody. Thanks for joining us today. So I'm going to be talking to you about the redundancy process before we then hand over to Kate to look at more of the legal perspective. So one thing to note, we are going to be launching a poll during this session today. We'd really love for everybody to answer the poll, and it'll be open for the next 10 minutes. And what we are going to do is then come back to those results of the poll, at the end of this session. So what would be best is for us to start with the next slide, please, about what actually is a redundancy. So we're here really today to give you a helping hand to guide you through this quite difficult and what can sometimes be quite an emotional process. Essentially, a redundancy is when an employer no longer requires a person's job to be performed by anybody. And essentially what that means, it's the complete elimination of a role. However, it may also be the redistributing of the duties of the role amongst other people in the business. So a genuine redundancy means that the employee is being dismissed, and as a result, nobody will be doing that role anymore. So if we go to the next slide, why is it important for us to correctly implement a redundancy process? Well, first of all, there is legislation around this. So the Fair Work Act provides that a person will not be unfairly dismissed as a result of a genuine redundancy. Really, the key word there is genuine. If a redundancy is genuine, that basically means that they cannot succeed in the event of pursuing an unfair dismissal claim. So when undertaking a redundancy, it's really important that as an employer, you do ensure that it is genuine. A genuine redundancy, if we look at it from the other angle, if it's not genuine, it means that the employee would still need that job. Also looking at if there is suitable alternative employment. So if you've got any vacancies in your organization right now, and if you fail to consult and provide opportunity to those people being made redundant, that may be deemed as unfair, and therefore it's not genuine. And also the real critical component is also that we have to follow the consultation requirements. And usually, in most cases, for our people here today, our various businesses, they would be from the modern award that is covered by your organisation or an enterprise agreement. So we'll go to the next slide, please. So making a definite decision. One of the critical things that we must also consider is the obligations to notify and discuss and consult with employees, and that is triggered once a definite decision has been made. So the minute that you decide as an organization, we do need to create some savings, we need to restructure, for example, you will have to, that obligation kicks in and you will have to start that notification, discussion and consultation process. And look, there are many stakeholders that you also need to consider, particularly the affected employees, and we'll be talking about the process that we go through with those employees shortly. But also if you are covered by a union or an enterprise agreement that names a union or an employee association, you will need to also ensure that the consultation period is covered, that includes them. Depending on how many people you are making redundant, you may also have to include Services Australia. Of course, your clients, they are going to be quite affected by the diminishing of roles and or potentially their lead in your business. And also an important factor is the employees who remain behind. And we call them the survivors or survivor syndrome is something that we'll talk about also in this webinar today. So we'll go through to the next slide, please. So once we have made that definite decision, it's really important to start then thinking about the logistics. So you know that you'll have to discuss this with employees. So that means, you know, how will you do that? So depending on how many people, it could be that you have a meeting with all of them at the same time. It could be that there are individual discussions and, you know, we don't have any group discussion. Also thinking about the methods by which the employees will be given an opportunity to respond. Under the legislation, consultation means that we are genuinely open to hearing our employees' feedback. And you have to also consider the way that you will receive that feedback. And you have to show that you've given genuine consideration to the responses from those employees who are affected by this change. What we would suggest is that you do consider the physical or virtual meeting spaces and also that you have some template documents. And if from a best practice perspective, if it was a large team meeting, I would suggest that you put some slides together or some written information because that will also be a requirement. So we'll go to the next slide, please. So why is it that we need to consult? Well, we mentioned at the start, we've got the Fair Work Act, but also the nature of the obligations to notify, discuss and consult arise from modern awards or your enterprise agreement, if you've got one, and or applicable workplace policies, or the terms and conditions of your employment contract. So all of these instruments may include these obligations around notification, discussion, and consultation. It's very important, particularly if you have a workplace policy or an employment contract that looks at the terms of policy, that you make sure that you adhere to those because otherwise you could be open to an unlawful termination claim. We'll go to the next slide, please. So when we look at the duty to notify, so within the enterprise agreement, a lot of, or modern award, these changes will really enhance derive from the terms of the major workplace change. And essentially what is a major workplace change? The trigger point really is once there has been a decision to make a major workplace change that is going to affect the organizational structure. It could be that you're introducing technology that may replace roles. It could be that a major workplace change is going to have a significant effect on the roles or the way that the roles are conducted, or you may just not need the positions at all. So we'll go to the next slide, please. So what is it that we need to consult? So we're still making this definite decision. Once you've made that definite decision, it's about ensuring that you get all of the employees who are affected together or individually and discuss the affected changes with them and their representatives if there are any. So you are required to discuss the introduction of the change, the effect of the changes and the likely consequence of that, and also open the conversation up to how you might mitigate the adverse effects on these changes. So I'll give you an example. Right now we're working in a recession. We know that COVID has hit many organizations. That has led to a downturn in business. And I know that because we've seen that across all of the speakers here today from the work that we do. So obviously that then in turn, and particularly with the financial assistance ending soon, may require organisations to review the structure of their organisation. So the likely effect on restructuring will be that there will be a termination of employment due to redundancy. So whilst you may know that, you still have to go through this consultation process. The opportunity to give your employees a response to allow them to give feedback will cover off your duties. And we know that it will come as a shock, and it's important that you do give employees time to give prompt consideration to any alternatives that they may suggest to avoid the situation. Now, there's no specific guideline in the Fair Work Act as to how long you must consult, and certain people will have differences of opinion on that, but it is very important that you do go through the consultation process. Next slide, please. So it is also really important that the discussions commence as soon as possible, and that you put the information in writing. And just like some of the factors that we've already covered, you must put in writing to the employees the nature of the changes that you're proposing, the affected change the effect that will have on the employee, and also any other matters. I'll move on to the next slide, please. Now, if you are going to terminate 15 or more people, it is really important that you notify Services Australia. Failure to do that will result, or it may result in a civil penalty. So Services Australia website, they do have a template letter that you can use and download. And essentially it's providing written notice to the Chief Executive of Services Australia, notifying them and also any other registered employee associations around the reasons for the dismissals, the number and the categories of employees who are likely to be affected, and the time period over which the dismissals will occur. It is really also essential that you provide that notice to them before dismissing the employees. And moving on to the next slide. So we've made our decision and the consultation process has completed. If you then decide after consultation that the determinations will occur, that will happen, and the employees will exit. Roy will be talking more later about the payment process, and Kate will also cover off some of the legalities around this once you have proceeded. But the other information that I wanted to share with you today really was around what we call survivor syndrome. it's really important to consider the morale of those left behind, particularly in a small, medium-sized organisation. Going through this process can be extremely emotional for everybody, including yourselves. So some of the top tips that we would certainly encourage is regular communication. So, and that comes from the top. So whether it's you at the top or you report into a managing director or a CEO or whoever that may be, that there really is clear lines of communication. It's really important, in my opinion, that we acknowledge that, yes, this has taken place. It has occurred. Honest communication will bring people back from the brink. And look, if people aren't informed, the knock-on effect of that is misinformation and relationships break down. And then the rumor mill starts. So a clear vision of communication is certainly going to assist with that. Building teams and looking at that that whole particular of reforming of teams, people may have taken on extra duties due to other colleagues being made redundant. So looking at re-clarifying roles, responsibilities, looking at some team building as to those that are left, who do they need to work with now? There could be new reporting responsibilities or lines. They might be managing a new team. So, you know, there can be a lot of change. It's also really important to allow that other team members and the whole organization to ask questions. And whether that's through an anonymous process or through team meetings, it really is critical about being open and transparent. Watching out for mental health and well-being at this time is also really important. And in general, we do know that mental health is on the decline, particularly in states like Victoria, who are still under lockdown, and other states who, you know, have not bounced back and are not back to their normal working or social lives. So mental health is something to watch out for, and there are plenty of organisations that provide that guidance and assistance for free. So next slide is a summary. Really, it's important that redundancy, it must be genuine in order to be considered legal. If it's not genuine, you are opening yourselves up to some legal issues there. There is an obligation to notify, discuss, and consult with employees, and that is triggered by a definite decision to proceed. Ensure that you check the relevant employment instruments before starting the process. So that includes modern awards, enterprise agreements, employment contracts, and any policies you may already have. Consider how you will notify, discuss, and consult. And also make sure that you provide relevant information in writing. If you are going to be terminating more than 15 people, it's important that written notification is given to Services Australia. And don't forget the motivation and the morale of those left behind. So we will hand over now. Oh, sorry, before we do that, we'll just bring up the poll. So has your organization considered redundancy as a strategy? Oh, we're at 50-50. There you go. Has your organization made any team members redundant since March? So 38% yes, 63% no. And does your organization plan on making redundancies? So 56% yes. So it's important, if you are planning that everything we talk about today is best practice. So I'd certainly suggest that you follow our advice and guidance. And look, we're all here as a helping hand to be able to assist you through this process. So I'll hand over to Kate.
Thanks, Matt. That was really intriguing, especially some of those stats that's just come through there. We know we see it through the payrolls, of the redundancies. And I think, yeah, it's quite an impact to this country. Definitely my walkaways from your presentation was the Service Australia obligations. I don't know how many companies actually have done that, and certainly a new one for me to keep up to date with, because I had no idea about it, and I'm sure many in this webinar would be in the same boat as me. So I guess, and the survivor syndrome, you know, I think we see it with businesses all the time. It is that after effect of the employees and how they feel after it, because it's never nice seeing their colleagues, you know, get made redundant and leave the workforce. And we all know the ripple effect in reality is those employees that are left are picking up that workload in majority of cases. So the mental health and the mental state of keeping your employees, you know, still focused, and but also that transparency of what's actually happening in the business is key. I definitely agree with that. All right, now we're over to the lovely Kate. So Kate is going to go over her section. She's from Murfitt Legal. We've had some excellent questions come through, which we'll cover at the end. So please, guys and ladies, do not stop with the questions, because we'll hit that at the end of my presentation, and bail up Matt and Kate for their expertise. All right, over to you, Kate.
Thanks very much, Roy. Look, COVID-19 has certainly been a crisis of significant magnitude, and I think given what's happening of late in Victoria and New South Wales, the light at the end of the tunnel, I think, can be really difficult to see. And so for many employers, decisions now continue to be about survival, even with the extension of JobKeeper until March 2021. So many of you, or perhaps your clients, may still need relief from all or part of your wages bill for the period of time over the coming months, but you also might need to avoid that financial impact of large-scale redundancy payments as you work to return to business as usual. Now, the COVID pandemic has seen many businesses being forced to make those really difficult decisions, especially in relation to whether it can keep all or some or none of its employees. And for employers who have been unable to initiate those alternatives to redundancy, for example, reducing employees' salaries or hours of work, or perhaps directing those employees to take unpaid leave or paid leave, the last resort then, and should be, as a last resort, to make employees redundant. Now, probably my choice of language then wasn't very good. I'd like you to remember that it's not about the person, it's not about the individual employee, it's about a position. So it's a position that is redundant because the position is no longer required to be performed. Now, navigating lawful redundancies is fraught with risk, and some of which Matt has touched on this morning. I guess if you take away only one thing from this hour, sorry, Matt and Roy, it needs to be that COVID-19 does not absolve employers from any of their legal obligations when it comes to redundancies. And so what we're seeing in the case law, which I will lead you through this morning, is a reinforcing of that by the Commission. So I thought it would be of some assistance this morning to detail some of those recent redundancy rulings from the bench, so specifically from the Fair Work Commission, in the hope that it will perhaps guide some of the more tricky decisions that some of you or your clients may either be facing now or you may face in the coming months. Roy, if I can have the next slide, please. Now, just recapping on what Matt has said, Matt's already addressed the three limbs of a genuine redundancy, and I cannot stress enough that in circumstances where you or your clients fall foul of just one of those three limbs that you can see there on the slide, you will not be able to avail yourself of that genuine redundancy protection. So that means if it's considered not to be a genuine redundancy because one of those three elements hasn't been satisfied, an employee will be able to proceed with an unfair dismissal claim. So if you fail to consult or if you fail to consider redeployment in a meaningful way, that shield of a genuine redundancy will not be available to you, and it will render, very likely, the termination of your employee's employment unfair. So without that shield, your employee or group of employees will be able to pursue an application for an unfair dismissal remedy, which will just then result in either time with me or any other lucky lawyer. But it could also result in time in the commission, which is taking you away from your business. And it's also a very costly exercise in terms of legal fees, or potentially an award for compensation, which is just money that your business probably doesn't have at this point in time. So moving on to slide 3. So despite these unprecedented times, the Fair Work Commission has taken the view that the COVID pandemic is not an excuse to forego processes when making employees redundant. And notwithstanding that many employers have tried to run that defence, it has not to date, and it's highly unlikely to ever be successful. So employers really have to strictly comply with those consultation obligations contained in an award or an enterprise agreement, an industrial agreement, or even a company policy before deciding a role will be made redundant. And Matt's spoken a lot about what is a consultation obligation and what that looks like. And I cannot stress that the COVID pandemic is no excuse for failing to consult employees in a redundancy process. So in the following recent cases, an employer's failure to properly consult in relation to what was otherwise a genuine redundancy actually rendered that dismissal harsh, unjust, or unreasonable. And it resulted in an exposure to an award of compensation, which, as many of you may know, can be up to 76,800, so that's the maximum compensation that can be awarded. But also then it's plus any loss of wages during that period between the date of termination and the date of the hearing. So the first case I just wanted to touch quite quickly on involved the employer Battery Energy Power Solutions. Now in this matter, the employer acknowledged that he had failed to consult in relation to what was otherwise a genuine redundancy, and the Commission found that absent that consultation, the dismissal was harsh because the employee had been denied a fair go all round. Now, the compensation was only quite small in that decision. It was only 1 week, but this was certainly the first case that the Commission was involved in, which involved a dismissal in which the employer contended that the redundancies were a direct result of the economic consequences of COVID-19. Now, Commissioner Johns in that decision was very clear in his judgment. There was absolutely no excuse for employers not to comply with consultation obligations, particularly in circumstances where the redundancy was caused by a significant downturn in work due to COVID-19. Now, the second case that I will labour a little, please bear with me, it involves Australian Services Union and Ausscript Australasia. I think some of you may find that some of these facts do ring true for your business, or perhaps you might even be in a heavily unionised industry. So Ausscript provides transcription services to courts and tribunals across Australia. They're a very integral and necessary part of our legal system. But earlier this year, Ausscript decided to close its Adelaide and Hobart offices, and it significantly downsized its Sydney office. And that resulted initially only in about 25 employees being made redundant. And at that point, the ASU, or the Australian Services Union, wrote to Ausscript about those changes and their failure to consult. And what resulted from there was a protocol that was established by Ausscript, and that would dictate their consultation obligations going forward. Now, unfortunately, because of the self-isolation measures and the social distancing requirements, we saw the courts and tribunals having to abort face-to-face hearings. And so we saw a further 60% reduction in the workforce that was required. And so that necessitated a significant downsize in its operations. So towards the end of March, Ausscript met with its employees and informed them that they were considering 4 options to ride out the pandemic. And they were office closures, voluntary redundancies, job sharing, or reductions in hours of work. There was a staff meeting that was convened, but then the staff were only given 3 days to elect one of those 4 options. And during this consultation period of 3 days, the employees were actually stood down. Now, the union wasn't given any heads up as to this proposal, nor were they involved in that consultation process. And so they made an application to the Fair Work Commission to really avert further redundancies and to urge Auscript to consider a range of further alternatives rather than considering redundancy. Unfortunately, Auscript decided to press ahead, and they then ended up, I believe, closing the Melbourne office and immediately informed its employees of their immediate termination due to redundancy. So in that case, given the facts that I've just outlined, the Commission held that Auscript hadn't in fact engaged in a genuine consultation process. They said it had just been conducted for mere show. It didn't provide the employees with an opportunity to actually influence the decision. It had absolutely no value, and it was quite a hollow consultation process. And so I guess the importance that I would urge you to take, or the lesson that I would urge you to take away from that case, is that consultation has to be a genuine opportunity for the individuals, the employees, to express a view about the proposed changes in order to seek to persuade the decision maker, you or another one of your colleagues, to adopt a different course of action. So in that case, unfortunately, Auscript were found to have not consulted, therefore it wasn't a genuine redundancy, and their employees were able to proceed and ultimately succeed in their unfair dismissal claim. Very briefly, there is a third case most recently, and this is important because it addresses consultation obligations under a modern award. And I noticed one of the questions that came through was whether if there's no applicable modern award, do you need to consult? Matt may have a different view on this. My view is that it's best practice to engage in a consultation process, even where there's no positive obligation under an award. Anyway, in this case, there was a positive obligation. The Clerk's Award applied. And the Fair Work Commission found in this case that the Clerk's Award has a very prescriptive consultation process that's detailed in that award. And because the employer had failed to comply with that consultation process that's stipulated in the award, that it wasn't a genuine redundancy. What was also important in this decision is that the employee that was affected, she was actually away on leave. And so whilst there had been some form of consultation, the employee hadn't been able to participate because she had been on leave. And it was when she returned from leave, the partner of the firm had done some calculations, and he approached her and tried to suggest that she would be financially better off if her employment ended and she could claim job seeker. So ultimately, her position was made redundant. She commenced an unfair dismissal application, and the Commission in that decision said that really any written communication should be for the purposes of providing information to give them an opportunity to understand the changes and the implications of those changes, and to enable employees to make suggestions and ask relevant questions. But certainly just being given a written piece of paper with some calculations and being told that she would be better off under job seeker wasn't sufficient consultation. I will stress in that case, because it is quite important, and I believe it's the only one to date of its kind. When the Fair Work Commission was awarding compensation to this employee, they actually calculated the compensation by reference to her higher rate of pay under the JobKeeper scheme. So it wasn't just her ordinary base rate of pay. They actually they took into account that had she remained employed, she would have received that higher rate of pay under JobKeeper, and therefore calculated her loss by reference to the JobKeeper scheme. Okay, moving on to slide 4. Now, I'll very quickly go through this decision, conscious of the time. Look, in the midst of COVID-19, we've had a number of clients approach us about they're struggling under the financial pressures of the pandemic, and so they're considering selling. The lesson from this particular case, and I won't pronounce it for fear of mispronouncing it, so I do apologise, but essentially is you are not, as an employer considering to sell a business, again, you're not protected from failing to consult simply by virtue of you possibly thinking that you're going to disclose confidential information and should therefore not have to consult with the employees. So the dilemma in this case was, at what point in time should the employer disclose to staff the impending acquisition and its likely impact on their continuing employment. So unfortunately, in this particular case, the employee was told very, very late in the process. I think, in fact, it was sort of the morning of the day that she was to be made redundant, was that an acquisition was occurring and that her position would be no longer required and she would be paid a month's wages and she could then go on and find a new job. She hadn't received any prior consultation prior to that morning. And so she subsequently filed a claim for unfair dismissal. So the employer, there was an applicable award. It was the Banking, Finance and Industry Award. And the employer sought to defend the absence of consultation by reference to this provision in the award that said an employer was not required to disclose confidential information, the disclosure of which would be contrary to the employer's interests. And so the employer stated that it would have been contrary to his interests in this case to disclose information relating to the acquisition of another business, and it was highly confidential and highly sensitive. Commissioner Cambridge in that case said, well, in fact, no, the term doesn't relieve the employer of the obligation to discuss the change. It only allows that as part of those discussions, the employer is not required to divulge or disclose confidential information. But there was still very much a need to consult, and informing an employee at 10 a.m. in the morning that her job would finish by close of business was not sufficient. Next slide, please, Roy, slide 5. Now, this is probably going to be particularly relevant for a number of you or your clients, and it's where you identify that an employee's role is no longer required, but the business simply cannot afford to pay redundancy pay. Now, what do? Now, my fear, just slightly coming off topic, with the extension of JobKeeper until March 2021, my concern is that businesses that are currently really only surviving because of JobKeeper, when that assistance falls away in March, you are going to find then that your business may not be able to survive absent those JobKeeper payments. And so you will be then obliged, and you'll need to make a number of employees' positions redundant, and you'll be obliged to pay them, if you have more than 15 employees, redundancy pay. It is highly unlikely that at that point, coupled with all the additional accrued leave entitlements, you'll be able to pay the redundancy payments that will become due and payable. So there have been a number of decisions where the commissions have intervened and reduced those redundancy pays. So some of you may not be aware, but the Fair Work Commission, on application by an employer, can in fact reduce those redundancy payments that would otherwise become due and payable. Now, to date, there have only been 3 contrasting, I must say, cases arising amidst the COVID pandemic, where the Commission has intervened regarding the amount of redundancy payment. The first one was an architectural firm, Mason Architectural Joinery. It was a small business, and it sought permission to reduce an employer's redundancy pay from 7 weeks just to 1 week. It said it couldn't afford to pay the full entitlement of 7 weeks. Now, the commissioner in that particular case calculated sort of the difference, and at the time, the difference in monetary in the monies that would become due and payable. It also looked at the financial position of Mason Joinery. Now, Mason Joinery its business has been significantly curtailed during COVID. Its business had only improved slightly since the termination of the employee's employment, but it really hadn't received any business income for about 2 months. And so it found in the employer's favour, and it reduced the employee's entitlement to redundancy pay down to that 1 week. However, unfortunately, in Worthington Industries, the employer wasn't permitted to reduce redundancy pay. In that case, it was deemed that the employer actually did have the financial means to pay the full entitlements, and it was actually likely to be eligible for the JobKeeper payments. And so I think in that case too, the employer actually did concede that it had the means to pay and it did have money in the bank, even though in the future it was likely to have a deficit and there might be cash flow problems. At that point in time, it had sufficient monies to pay. The third case, just very quickly, Acme Preston, they did succeed in having redundancy payments for 4 of their workers slashed by almost 70%. And in that case, the business was operating at a loss. It was still operating at a loss despite having about $200,000 being injected into the company by the owner and his family members. And they really, they were trying all types of cost minimizing measures, but they really just couldn't satisfy those payments. So the commission intervened. And I think in that case, they even only had $38,000 in the bank, which wouldn't have even covered the redundancy payments in any event. Okay, slide 6. So very quickly, this case of real property, it addressed the issue of whether an employer could reduce redundancy pay on the basis of the employee obtaining other acceptable employment. Now, in this matter, the employer's application to reduce the redundancy entitlement, I believe from 6 weeks to 2 weeks, was on the basis that the employer had offered other employment to the employee. But it was actually found that the new role that had been offered was not acceptable employment. She was required to work the same number of hours, performing the same duties that she'd previously been employed to do, but for significantly less pay. And so accordingly, that role wasn't acceptable. So when the employee declined the offer of that new role, she was in fact entitled to redundancy pay. And the commission found that the employer should cough up and pay the full 6 weeks. Slide 7, please, Roy. Now, this case, again, in that redundancy context, was whether it dealt with the issue of whether a reduction in hours amounts to redundancy. So Broadlex Services and United Workers Union, in this matter, the federal court, actually, it wasn't a Fair Work Commission decision, the federal court found that reducing an employee's hours from 38 to 20 without her consent amounted to a termination of her employment, and it gave rise to an entitlement to redundancy pay. And this is really critical for a lot of you or your clients that are considering reducing your employees' hours of work. In reaching this conclusion, His Honour drew a distinction between termination of the employment relationship and termination of the employment contract. And Her Honour found that by reducing the employee's hours from 38 to 20, so almost in half, and certainly without the employee's consent, she found that the employer had repudiated the employment contract, therefore bringing that employment relationship to an end. And so the employee accepted that repudiation and then sued. So please, if you are considering reducing an employee's hours or pay due to COVID, you will need to really consider if that would amount to a redundancy and therefore a claim for redundancy pay. Look, there's just 2 very quick, Roy, I know I've run over time. The second last case just deals with a situation where the question was posited, did redundancy amount to adverse action? Now, for some of you, adverse action may be a completely alien term. Hopefully not. Adverse action is really a situation where an employee has exercised a workplace right. And that workplace right might be they've made a complaint or inquiry about something pertaining to their work, their hours, or their conditions. And as a result of that employee exercising that workplace right, they have suffered adverse action. And in this context, the employee said, I exercised a workplace right to make a complaint or inquiry. And as a result of doing so, I was selected for redundancy. So they weren't challenging the genuineness of the redundancy. They were saying that, but for my complaint, I wouldn't have been selected. Now, adverse action claims are incredibly costly for employers. They are argued in the jurisdiction of the Federal Circuit Court or Federal Court. There's no cap on the compensation, and also employers and individuals directly involved in the contravention can be found to be liable, and penalties in the amount of about $66,000 can be awarded to the employee against the employer, and cost orders can also be made against individuals. So perhaps some of you are attending today. So in this particular case, even though it was found that the reason for selecting her for redundancy had nothing to do with her making the complaint, I guess I come back to some of Matt's comments. What was beneficial for the company in this particular case was the amount of documentation and the very thorough redundancy process that was implemented, that the employer was able to rely on to discharge the burden of proof. And look, very, very quickly, just to conclude, I would caution employers, especially where you're dealing with executive employees, and they're certainly not immune from being made redundant. Where you engage in an unlawful process, perhaps where you've taken adverse action or it's not a genuine redundancy, the employing entity will lose the benefit of any post-termination restraints of trade and those protections that are afforded. So if you've got a restraint of trade which perhaps restricts one of your executives from working with a competitor or from soliciting clients, if you do not engage in a proper redundancy process and you're found to have breached your employment contract, and the employee is successful in its unfair dismissal claim or successful in its adverse action claim, you will lose the benefit of those post-termination restraints of trade, which could then be a very, very costly exercise for you as you're watching clients leave or you're watching your star employee work for a competitor. So Roy, I do apologise, I have gone over, but I will conclude there.
All good, Kate, no problems at all. It's very interesting, all these case studies must keep you up at night, and it certainly keeps me up at night knowing basically you can't skip any of these steps in the process, even if in pandemic. And I think that's the walk away from that is you're not immune as a business just because it's a pandemic or you're trying to clean up house. You've got to go through that three-limb process and do it properly. All right, we are running a little bit over, so I'm going to move through my slides pretty quick, which is all good. And just to make sure that we can allow plenty of time for the questions that will be coming through or have been coming through and answer as many of those as possible. So the first bit I wanted to cover was talking about the income or the genuine redundancy payments. Now, one of the common little myths that people just kind of overlook from a payroll officer's perspective is not all the time is lieu of notice can be included in your lump sum D, okay, or your tax-free portion. And where the ATO kind of spells it out is if you were to normally terminate, so let's say a sales role, and you would be paid that in lieu of notice on a termination, so you wouldn't have to work it, then if that role was to be made redundant, you can't include that into your lump sum D component. Now, it is obviously very hard for someone to, most companies will not have that documented in a process, but where it can be documented is when you go through your ISO, say 27001, a SOC 2 audit, and you document your process of what happens with terminations for certain roles, that's where your policy will come into play should you be audited down the track. So the two major roles that we always generally see is the sales roles. They usually don't work there in lieu of notice, and executives. They usually in the C-suite usually don't work there in lieu of notice in many cases. So just be wary as a payroll officer to know if you normally would pay out the lieu of notice rather than employee work it, then if they were to be made redundant, the role, then you wouldn't include it into that lump sum D component. All right, moving on. So the other things to be very conscious of is we talk about the age-based limits. Now, what the age-based limits, a lot of people are not aware of this. If you make employees redundant or the position redundant, and that employee is over the age of, let's go worst case, 67, you don't actually get any lump sum D component. Now, there's really no actual sense of why that happens. So it's just something to be very mindful of, because we do see a lot of this happen and people don't understand why the system is not giving them any tax-free lump sum D components. So be very wary that depending on the age or the date of birth of that employee will determine if they're applicable or non-applicable to that lump sum D or the tax-free portion. Okay, so that's the age-based limits right there. We have what we call the preservation age as well. Now, what the preservation age drives is to do with ETPs. So we are talking on whether you're getting your ETP payment at 17% tax or the 32% tax, assuming you're not exceeding the whole of income cap. So that is what the preservation age does. So it's something, if you are building your little templates to do your redundancy quotes, is to ensure that you're capturing the employee's age on those Excel templates, Word documents, however you're producing these redundancy quotes, and to know what the actual consequences of people's ages are at the time they're getting made redundant, okay? Because that does drive different rates of tax or tax-free components. Now, when we work on actually calculating your lump sum D component or the tax-free portions, a common trait that people do forget is to add the first base amount. So currently this financial year, it is sitting at $10,989. And people generally forget to add that first year. So if you've done 1 year completed service, it's actually in the total of the 15, or call it the 16,000, right? So here's a simple count. You've done 10 years. It's 10 times the consecutive years of $5,496, plus the $10,989. So for example, a lump sum D payment, if you were to get paid $100,000, let's say it's a golden handshake, all those kind of things, it equates to $65,948 of that payment of the $100,000 would be tax-free, okay? So that's how essentially the lump sum Ds works. If you are using definitive, this would automate that based on the years of service. And it is also very important when we talk about years of service that you look at the actual true hire date. So sometimes they've been secondment to another business unit, or they've moved from another entity, part of the group. So in definitive, excuse me, you might have the hire date of when they started in that entity, but you've got an actual original hire date. So the calculations for definitive will be based on the actual original hire date. So it's important that that's updated on their master record before you process a redundancy accordingly. Now, the other things with the financial year, or the base amounts and the service amounts, is they are incremented every year, okay? So they are indexed, so we'll get told roughly around May of each year what the new thresholds would be. And again, the technologies in the payroll systems usually have those updated automatically for end of financial year. Now, when we talk about redundancies and working out people's years of service, there's a couple of things just to note. When you have gone from a casual employment to say a full-timer or even to a part-timer, and now the role's made redundant, that casual portion of that employment is still included in your completed years of service. Okay, so don't forget, it's not just the part-timers and full-timers that is applicable. You've also got to look at your casuals. Now, when we talk about casuals, there's the thing with JobKeeper that's it's going to be the hidden, I guess, knife in some of the businesses out there where they've got JobKeeper for their long-term casuals. Now, when we've seen all the wording come out, we talk about the redundancies being regular and systematic based on their, I guess, the rosters, the shifts that they get. So if you've now gone and got JobKeeper for your casuals, be very mindful now making those roles where you just terminate normally a casual based on, hey, don't need you anymore, that's all good. You might actually be liable to make that position redundant, okay? So you just can't assume it's a silver bullet because they're a casual employee. We move on to in lieu of notice. This is an interesting one. So when we talk about completed years of service for the calculation, should an employee, let's say, went on maternity leave and took a year's maternity leave, unpaid leave, or any unpaid leave throughout that period, that is not counted towards your completed years of service. So let's just say, for example, I've worked for the business for 10 years. I took a year off on unpaid leave, parental leave. It would actually be counted as 9 years completed years of service for that calculation. Where the little quirk is also for the in lieu of notice period that you pay out for that employee, it's actually based on the 10 years, okay? So the broken service is not included for the calculation of in lieu of notice. So be very, very mindful of that. And you've got the employees that are over 45, which is the extra week in lieu of notice. So just be mindful of these little hidden quirks that will cause a redundancy calculation to be wrong. And then suddenly you're doing back pays and causing more grief to your employees in an event of a redundancy. It's not a nice thing anyway. We talk about ETP caps. Okay, so the ETP cap, I think for this financial year is 215,000 with the whole income cap of 180,000, which hasn't been indexed. So why that's important is it's also including when you are paying out in lieu of notice, even as a redundancy, you need to make sure you're still picking the relevant pay items because that is still the superable component of that payment. Okay, so you can't forget that you still need to pay super on the in lieu of notice component. So that's another little one to be very mindful of. But when we talk about, I'm going to pay out this particular employee a $400,000 golden handshake based on the years of completed services, let's say a portion of that is 100,000 tax-free. The remainder will now sit onto an ETP pay item. Now, a redundancy is what we call excluded. So excluded pay item will be a code R for those who are not familiar. But remember, any portion over the cap, being now 215,000, will fall into an ETPO, okay? And that will be taxed as a whole of income cap, okay? So again, it'll be at the highest tax rate essentially, because obviously that payment is quite significant. So technologies like Definitive will automate those calculations for you as long as you put it in the relevant pay items. However, it is something, again, if you're doing all these spreadsheets to give it to an employee at the time of the redundancy, it's important you've got those formulas in the spreadsheets that is calculating it correctly, because the last thing you want is to produce the document of redundancy of what the payout will be. And then when payroll goes and processes it, it's actually completely different because of the tax treatings or their age or those kind of things of in lieu of notice. So you want to make sure if it's HR that's producing it, they're in sync with payroll, and vice versa. If it's payroll that's providing it to management, the calculations, someone has checked those spreadsheets. We see it time and time again, those spreadsheets have been done, let's call it in 1980, and it hasn't evolved, or Margaret's changed it, or Beck's gone in and changed it. And the formulas haven't been correct, and it causes nothing but grief when it comes to the employee when they've caught an underpayment, and you don't need that noise as a business. All right, so the easiest way we always explain it to clients is when we talk about ETP types or codes. So in Definitive, that will be driven automatically by the termination type anyway. But the easiest way I always explain it to people, there is 4 major reasons that will fall under code R. Anything else will fall under code O. So it's the easiest way to remember it. So approved early retirement, a genuine redundancy, invalidity, and compensation for personal injury, unfair dismissal, harassment, or discrimination, okay? So compensation payments as a whole would be the category, but they're like the 4 types that would fall under it. So you just need to remember those 4 types, and everything else would be a code O. That's the easiest way to remember it. But again, we've just done a reference. There is reference on the HL website should you forget which code to use coming to processing a termination, or in this case, particularly a redundancy. All right, death has its own kind of codes. Again, definitely on the rarity, but that's something just to note as well. A death termination is treated completely different, which is not obviously going to be a position made redundant when you've passed away. Okay, so the final points. In lieu of notice accrues super. Please do not forget that. We see it time and time again in audits that we do where people have forgotten to pay super on lieu of notice, just even in normal terminations. But again, on the redundancy is the one that people generally trick up on because they're so quick to put it into a lump sum D, forgetting they need to put it into a lump sum D superable pay item. Okay, so it's just quite important to remember that. Remember, when you talk about your pay items, it will have different ways to treat the payments. Okay, so you need to be mindful that your setup is done correctly. It is getting maintained yearly. So just do that quick spot check financial year to make sure you are ready, especially if you're going to start doing redundancies, as Matt and Kate have indicated. You've got to get the process right, but then obviously the payment is the final nail in the coffin. So you don't want to fall over and not execute that correctly either. RDOs or roster days off or time in lieu policies that are accrued will be determined whether they're superable or not based on how they're accrued. Okay, so that is again another thing that tricks people up. It depends, and there's a lot of case studies on there about, well, when is an RDO accrued for super and when is it not, and vice versa for time in lieu. So please understand your policy and which category you fall into for that business when you're doing the accrual, because that will impact your termination, especially on redundancies. Also, what we also see that upsets more the finance team is when you go do the redundancies and you are putting these balances on those pay items of the ETPs and you're putting it onto the time and lieu's or the lump sum D, sorry, they forget that the journal side of it needs to actually reduce that liability now back to zero. So the way you do that in systems, should the pay item not be linked, the termination pay item not be linked to that payment or that leave type, is you would add that accrual item and bring it back to zero. Because if you don't bring it back to zero, finance has still got that sitting on their balance sheet as a liability. Okay, very, very common mistake by a lot of payroll officers, because they forget about what the impact is now to finance when the ledger doesn't reconcile come end of month or end of quarter when the finance department goes and does it. All right, I'm going to cut off there and open it up to all the different questions. So just on these final slides, what we just want to cover is please stay up to date with all the industry news. HR expert Murphy Legal does a lot of webinars of different topics. There's one coming up tomorrow about insolvencies and to prepare for that. So again, if you are interested in that, please just reach out to Murphy Legal on their website and you can easily enroll in that. That's a free event. Also, HR experts, whether it's social media or their newsletters, we will send those details out. And it's definitely great to get those little snippets of what's going on in the world. There will be a survey that will pop up at the end of this. Please, we ask you just to quickly fill it out, just so we can make sure we bring relevant topics, what you enjoyed or didn't enjoy about today, and just to make sure we're honing in on that. And we'll also be sending a link of this recording at the end of the week. So again, if you've missed it or any of your colleagues couldn't make it, feel free to please share this along. All right, I'm going to open this up. Beck, did you want to start asking some of those questions?
Oh, Roy, I'm so sorry. I was just being a little bit too keen and I've gone in and answered most of them, but by writing back. I'm so sorry.
All right, did you want to read out some of them then, Kate?
Yeah, I thought, I'm so sorry. Sorry, Beck. Look, one that has come up, it's about how long after redundancy has been notified does an employee have for submitting an adverse action or unfair dismissal claim? Fiona, as I said, an employee has 21 days from the date of termination and they have to elect. Some years back, they could bring an unfair dismissal claim and then sort of almost have a second bite of the cherry, but employees now have to elect 21 days to bring unfair dismissal or a GP claim. There was a good question from, I think, Ashley about how much time does an employer have to provide payment related to termination. So most modern awards actually, as I said, stipulate that final pays have to be made within 7 days of the date of termination, and that's including all accrued entitlements and redundancy pay. Most employers tend to actually do it on the termination date, or within that next pay run, as long as it falls within sort of 7 days of the termination date. Ashley also asked quite a good question about payment in lieu, and if an employer decided to pay notice in lieu rather than getting an employee to work it out, would that sort of impact on whether a redundancy is considered genuine? And I've said, for the purposes of considering whether a redundancy is genuine, no, it wouldn't. As Matt and I have said, it's those 3 limbs. Is the position required to be performed by anyone? Second limb, have you complied with any industrial instrument in relation to consultation? And then the third limb, have you considered redeployment opportunities? So as long as you can satisfy those 3 limbs, it will be considered a genuine redundancy. If you fell foul of one of those 3 limbs, then the Commission then had to consider whether it was a fair dismissal. You might find that any sort of arrangements pertaining to working out the notice or pay in lieu of notice may impact on the fairness. Sorry, Beck, I'll hand back to you because I know there's some more questions that have come through.
Thanks, Kate. Thanks for answering those questions too. It was really helpful. So I'm going to ask one question through to you, Matt. What would you say is the difference between a discussion and a consultation?
Look, what I would say is that consultation is genuinely asking an employee for their opinion or asking them to provide feedback, and then also it's about what you do with that feedback, about giving genuine consideration to it. So I think that is the real difference. A conversation can be quite one-sided, whereas consultation is two ways. Look, the reality is, even after the consultation, you still may proceed to make the role redundant, but it is a procedural requirement that is enacted in under the Fair Work Act, or well, particularly in the modern awards or an enterprise agreement.
Okay, perfect. Thank you very much. And I have another question from Natalie. If a function has been removed from the business and an attempt to redeploy has been made, if that new arrangement isn't working, can a genuine redundancy be made 6 to 8 months after dissolving of the original role or department?
Kate, look, I think, and Kate, happy to take your opinion, but if it's that long afterwards and the role isn't working out, redundancy shouldn't be about performance. Redundancy is about the genuine need to reduce the headcount. So, and we do see this quite often, where an employer may come and say somebody isn't working out, I want to make them redundant. That is actually not a genuine redundancy. So there are other methods available to employers if that is the situation. Kate, I would welcome your input as well.
Matt, look, I would agree. Coming back to those critical 3 limbs, the first limb is, and if you remember some of my comments earlier on, redundancy is not about an individual, it's about a role that is no longer required. So if the role is no longer required, then you can satisfy that limb, then you're in the arena of a redundancy. I think too, specifically, Natalie, in relation to your question, it looks like the substantive role was no longer required. As an alternative to redundancy, you've redeployed them. That new role then, into which the employee has been redeployed, becomes their substantive role. And if it's no longer working out, but you still require that new substantive role, Matt's right, it's not going to be a redundancy, and you need to be looking at, possibly performance managing that employee.
Thanks both Kat Kate and Matt. I have one more question. This one has come up twice and it has actually been answered by both you, Kate and Matt, throughout the presentation. But do you need to conduct a consultation process with the affected employee if they are not covered by an award or EBA?
Yeah, so I think Matt and I have both answered that, Rebecca. So our advice, and Matt, I don't want to speak for you, but I think it's consistent.
Yeah, it is.
Strongly encourage you to engage in a consultation process. It's good practice culturally. It's much better for your business. And I would encourage all of you, even if there's not an applicable modern award, I would say on that point, given the increased scope of the miscellaneous award, it is now more than likely that there will be some modern award or industrial instrument that applies. And I would strongly encourage all of you to engage in a consultation process. I did notice there has been a question popped up about how long is an adequate consultation process. Look, no, there's no, it's not specified in any award. Even the decisions don't specify how long consultation should take. A lot of it is based on your business, the industry, how many employees are being made redundant. What I would say is in most circumstances, the Commission, in awarding compensation for failure to consult, will usually award only, and especially in the conciliation conferences where we're trying to arrive at a settlement, payment, we're usually looking at about 2 weeks. So the Commission will say, well, had you engaged in a proper consultation process, it probably would have been 2 weeks, and therefore the employee is entitled to that 2 weeks pay.
Perfect, thanks, Kate. And another question has come through, so we'll ask one more. And actually, I'm going to put this one to you, Roy. We have an employee on workers' comp and made redundant due to work have been completed, and the role isn't required anymore. We've paid the redundancy, but as per the insurer, we need to continue the workers' compensation payment. How will this be treated?
Yeah, so that will depend on the state that the employee falls in. So that is state-based workers' comp. But as a general rule, if it's still getting the workers' comp payment and the position has already been made redundant, it's a general case, won't be suitable and probably won't be accruing leave as a general case. So you just need to check with the different states on that. But your insurance provider will tell you how that calculation is based anyway. But what that will mean for a payroll is they're still really an employee on your books, so you'll still be facilitating that payment, whether it's for 6 months, 5 months, whatever the actual claim settled, until they get to a settlement, essentially. So just be mindful not to terminate them off your payroll system, even though you've just made a redundancy payment. You will need to now rehire until the settlement is done. But again, your insurance provider will definitely provide you guidance from a payroll officer's point of view of what and how to process that payment because it is state-based.
Perfect, thank you very much. And we are going to finish up now, just because we are running a bit over time. But I want to take this opportunity to thank both Kate and Matt for joining us today in our webinar. I really appreciate you guys getting involved and sharing your expertise. I know I've really learned a lot from this session. And just a reminder, as Roy said, make sure you stay on after the webinar and fill in that survey for us. It will just help us improve our webinars in the future. Perfect.
Excellent. And I want to echo that. Yeah, just want to echo that. Thank you, Kate. Thank you, Matt. And for everyone that's been watching, really appreciate your time. I know there's the real Zoom fatigue going around, especially in Victoria. So please, anything you need, we're here to support you. So please just reach out.
Thanks very much, Roy.
Thanks, Roy. Thank you, Rebecca. Thank you, Kate.
Bye.